After shaking down CBS, ABC, Google, Meta, and Twitter, Donald Trump has a new target, and it is you and me and every other American taxpayer. Trump wants $230 million from the U.S. Treasury to compensate him for the Russia investigation and the stolen documents case. At a press conference last week, he agreed that it was weird to act as judge and jury in his own case, but he was ready to do it.
And it's awfully strange to make a decision where I'm paying myself. But I was damaged very greatly, and any money that I would get, I would give to charity.
There is no lawsuit. There never was. But is it legal for the president to pay himself hundreds of millions of dollars from the U.S. Treasury? And if it's not legal, is there anything that can stop it? Back in 2024, Trump's sweatiest lawyer, Daniel Epstein, went on Fox Business and announced that Trump planned to sue the government over the Florida documents case.
And that's what President Trump believes the entire special counsel investigation was about, interfering with his ability to get elected.
We made a whole video calling it Trump's dumbest suit yet, which was true at the time, but then Trump sued CBS for tortiously editing a video of Kamala Harris, and we had to revise our rankings. Epstein represented Trump on the CBS case too, by the way. The network told Trump to take a hike because the suit was nonsense, but then Trump got elected and made it clear that if CBS's parent company Paramount wanted its merger with Skydance to go through, that lawsuit would need to be settled, which it was for a $16 million donation to Trump's presidential library, which does not exist. But it does have a plane. That was one of the first times that Trump wielded the power of his office to extract cash from his enemies, but it wasn't the last. As we said last year, Epstein did not file a lawsuit. What he filed was a standard Form 95 demanding compensation under the Federal Tort Claims Act. The FTCA, or FATSA to its friends, is an exception to the rule of sovereign immunity that says you can't sue the government. Sovereign immunity is left over from the time when we had absolute monarchs who were above the law, which existed only to bind the king's subjects. And thanks to the Supreme Court, we're back there again. Wait for it. FATSA details the situations in which the government waives its sovereign immunity and lets you sue it. In the main, those involve cases of harm to your property or your person. So if the mailman sideswipes your car, or if you get injured at a hospital run by the Veterans Administration, you file an SF-95 with the Postal Service or the VA or whichever agency harmed you. That agency has 6 months to say yes or no to your claim, after which you have a further 6 months to sue. Generally, you can't sue the government for what's known as intentional torts. And this one's a little bit complicated, so let's let the nice folks at the Congressional Research Service walk us through it. An intentional tort is when I did something to you knowing that it was likely to harm you. Under what's known as the intentional tort exception, the government cannot be sued for all the stuff Trump says he's getting paid for. No false arrest, malicious prosecution, or abusive process. But there is an exception to the intentional tort exception called the law enforcement proviso, and that does allow plaintiffs to recover for certain intentional torts committed by federal investigative or law enforcement officers. That list includes malicious prosecution and abusive process, which sounds like Trump is in the clear, but in reality, it's almost impossible to recover for intentional torts by the government thanks to what's known as the discretionary function exception, which preserves the federal government's immunity when an employee's acts involve the exercise of judgment or choice. And that exception functionally swallows the rule immunizing prosecutors and police from most lawsuits, because there's a lot of stuff the government has to do by statute. The Bureau of Prisons has to feed prisoners in its custody. The post office has to deliver your mail. That's all non-discretionary. But prosecutorial decisions are quintessentially discretionary. The Attorney General and the Justice Department decide whom to investigate and prosecute and where to allocate their resources. Now, technically, the discretionary function exception, or DFE, is a two-pronged test. Once courts determine that the allegedly tortious government conduct was discretionary, they ask whether it's potentially influenced by policy considerations. But in reality, courts construe that so broadly that it's almost impossible to win against the government. If the first element of the discretionary function exception is satisfied, then courts will generally presume that the second element is satisfied as well. The Supreme Court has held that when an established governmental policy, as expressed or implied by statute, regulation, or agency guidelines, allows a government agent to exercise discretion, it must be presumed that the agent's acts are grounded in policy when exercising that discretion. According to the Harvard Law Review, in FTC litigation, when the government has invoked the exception at the motion to dismiss stage, it has succeeded in dismissing nearly 75% of claims. So, TLDR, it is almost impossible to prevail in court on a FATSA claim, and the deck is heavily stacked against civilians. And by the way, that's even more true when it comes to prosecutors who enjoy broad immunity for their work. Oh, and one more thing. Even if you win your FATSA claim, you can't get punitive damages. So compensatory damages compensate you for your actual harm, and punitive damages are imposed by the court to serve as a disincentive for the plaintiff to do that bad thing again. But FATSA does not permit plaintiffs to punish the government in that way, and that is black letter law. Okay, now that we understand the FTCA, let's talk about Trump's $230 million claim. But first, since we're now living in a world where Trump has near infinite immunity and the law is increasingly being decided in the court of public opinion, almost 400 sources covered the DOJ settlement story, with only a small percentage of right-leaning outlets picking it up. And depending on the sources you follow, it's hard to tell if they were even talking about the same case. And herein lies the danger. It's not just facts that shape public opinion, it's how those facts are framed. When you scroll down to see how this story is being covered by every outlet, the frames can have subtle differences that make a huge impact. From the left, Trump is demanding the $230 million, and headlines are quick to point out how blatantly corrupt that is. From the right, headlines focus on Trump's speculation that the DOJ probably owes him money for the past cases. And from the center, headlines typically focused on Trump's belief that he has final say in the matter. This type of analysis is why Ground News has been my favorite way to stay up to date with the news since 2023. So I want to thank them for sponsoring this video. They've been a longtime supporter of this channel and independent news media at large. Ground News is an app and website that helps me see the full picture by pulling in news from thousands of sources worldwide. I can compare coverage and uncover the political bias, reliability, and most importantly, see who owns the sources reporting the news you're reading. And it's not just me. Ground News has even been recognized by the Nobel Peace Center for its impact on media literacy. I also love their blind spot feature, which shows you stories that are underreported by either side of the political spectrum. If you're only getting your news from one or two places, you might miss related stories like this one of House Democrats launching an investigation into Trump's shakedown of the DOJ. Nobody on the right covered it. If you care about true context and evidence like I do, I recommend you check out Ground News. It's the tool I personally rely on to stay on top of breaking news with clarity, and as a legal eaglet, you can get 40% off the Unlimited Access Vantage plan, the same one I use, by scanning the QR code or clicking the link below. By subscribing, you're also supporting an independent news platform that's working to make the media landscape more transparent and balanced. So sign up for Ground News today, and I will see you in court. According to the New York Times, Trump filed two separate SF-95 complaints. The first claim, lodged in late 2023, seeks damages for a number of purported violations of his rights, including the FBI and special counsel investigation into Russian election tampering and possible connections to the 2016 Trump campaign, according to people familiar with the matter. So Trump wants $115 million from the Department of Justice related to investigative decisions that it made in 2016, 9 years ago. The investigation continued into 2017 when Trump's own appointees ran the DOJ, and it ended when special counsel Robert Mueller submitted his report in March of 2018, 7 years ago. So Trump is the plaintiff, but he's also the defendant, since his own administration is the one that supposedly injured him. Although most defendants have to reach into their own pockets to pay a judgment, and Trump is playing with taxpayer dollars. And, by the way, he's also the judge because he is the one who decides if and how much he gets paid. Okay, there are one or two teeny tiny problems with this. First, we are long past a time to make a claim on the Russia stuff, both because the statute of limitations and because of FATSA's requirement that the injured party has to file suit within 6 months of having his claim denied. Second, which of the intentional torts under the FTCA exceptions is Trump claiming here? It can't be malicious prosecution, since Trump was never prosecuted. I guess he's arguing abuse of process, which doesn't really fit either. The test for abuse of process in D.C. was laid out in a case called Jacobson v. Thrifty Paper Boxes. It involves some sort of judicial or criminal proceeding initiated or exploited to accomplish some end which is without the regular purview of the process, or which compels the party against whom it is used to do some collateral thing which he could not legally and regularly be required to do. The end of the investigation into Russian interference with Trump's campaign was the Mueller report, which was mandated by the special counsel statute. And Mueller didn't compel Trump to do anything. Trump wouldn't even sit for an interview.
Did the president refuse a request to be interviewed by you and your team?
Yes.
Yes. And is it true that you tried for more than a year to secure an interview with the president?
Yes.
And anyway, the Inspector General's report determined that the investigation was appropriately predicated. And third, Trump was in the White House for most of the time. If the DOJ was so out of control when he was in charge of the executive branch, whose fault is that? The New York Times published Trump's second SF-95, so we don't have to guess at the content of that one. The premise here is that the search on Mar-a-Lago in August of 2022 constituted an abusive process, and any prosecution based on the fruits of that search was a malicious prosecution, and so Trump would like $115 million, please. Maybe the best way to think about this document is like those old deductive reasoning exercises, you know, the ones where they say, all dogs are mammals, cats are mammals, therefore cats are dogs. I believe that fallacy is called affirming the consequent. So no, you can't stack up a pile of true statements and say, Eureka, I have proved something that is objectively false. Or you can unless you're Daniel Epstein. His argument rests on the claim that the search on Mar-a-Lago was illegal. In fact, it was conducted pursuant to a judicially authorized warrant issued because the government demonstrated probable cause to believe that Trump was hiding national defense information and classified documents in his private club, which he was. Epstein points to internal dissent at the Justice Department, particularly testimony by Stephen D'Antuono, the former assistant director at the FBI's Washington field office, who said that he would have preferred to seek Trump's permission to search the property rather than executing a non-consensual warrant. Which is true. He did say that, but D'Antuono was not the FBI director and he wasn't the attorney general. That's like saying the regional manager disagreed with the CEO, and that's proof that the CEO was wrong. D'Antuono was an experienced guy, but it was not his call. How to conduct that search was an exercise of discretion, and for the record, D'Antuono was very clear about that in his testimony. He said several times during that hearing that the search was neither illegal nor against DOJ policy. He just thought it would have been better to do it a different way. Weirdly, though, Epstein left out that part in his complaint. Cats are not dogs. The malicious prosecution charge is similarly bizarre. Under Florida law, there are 6 elements to a malicious prosecution claim, and 2 of them are super problematic for the president. First, there has to have been no probable cause for the legal action, and here, 2 grand juries concluded that there was. Remember, there was 1 grand jury for the original indictment, and then a second one for the superseding indictment that added obstruction charges for that plot to destroy the evidence. Second, the plaintiff in a malicious prosecution case has to prove that he was the prevailing party. And while Judge Eileen Cannon did dismiss the case based on the theory that special counsel Jack Smith was illegally appointed, that did not make Trump the prevailing party. That was a collateral ruling, not a ruling on the merits. It's also a theory of special counsels that's been rejected in every other court to consider it, including the Supreme Court. But Daniel Epstein is still adding up cats and dogs to equal marmosets. He says that the fact that a court later determined that the special counsel's appointment was illegal, quote, reflects an absence of probable cause for the events leading to the indictment. That's a very careful fudge. Epstein knows that he can't blame Smith for the circumstances of the Mar-a-Lago search in August of 2022, since Smith wasn't even appointed until November. And so he says that Smith's illegal appointment means that the jury never found probable cause to indict, a sentence which refutes itself if you say it out loud. Epstein goes on to say that Attorney General Merrick Garland should have known that the Supreme Court was going to rule that the president was immune from prosecution for official acts. Ipso facto, the prosecution was malicious. He does not explain how presidential immunity would apply to a private citizen storing classified documents in his shower and refusing to give them back despite repeated requests and subpoenas for more than a year. In short, cats plus dogs equals cauliflower. But in some sense, treating this like a real legal claim gives it more consideration than it deserves. This is Trump ordering the government to hand him hundreds of millions of dollars and his hand-picked cronies saying, yes, sir. The mechanics of this payoff are equally outrageous. FATSA's settlements must be approved by the agency's senior leadership. Here, that's Deputy Attorney General Todd Blanche and Associate Attorney General Stanley Woodward. Blanche represented Trump in the Florida documents case, and Woodward represented Trump's co-defendant, Walton Nauta. To say that they are conflicted is a massive understatement, and their boss, Attorney General Pam Bondi, was also Trump's personal lawyer before taking this gig, so it would be wildly inappropriate for her to sign off on this deal. The Times asked the DOJ if Bondi, Woodward, and Blanche would recuse themselves from the decision. DOJ spokesman Chad Gilmartin said, in any circumstance, all officials at the Department of Justice follow the guidance of career ethics officials, which might be reassuring if Bondi hadn't fired the senior career ethics official at the DOJ in July. And then there's the amount of the award. Epstein's complaint demands $15 million in actual harm due to his legal costs in defending the special counsel proceedings before the U.S. District Court for the Southern District of Florida. $15 million is a suspiciously round number, and Epstein isn't showing his work, but he does drop a footnote that proves that Trump didn't pay his own legal fees anyway. That money was paid by donors to his campaign and political action committees, as Todd Blanche knows, since he was the one cashing the checks. So Trump is demanding the government hand over taxpayer dollars to pay him back for money he never spent in the first place. But remember when I said that punitive damages are categorically barred by the Federal Tort Claims Act? This document demands $100 million in punitive damages anyway. Add in the $100 million he's asking for the Russia investigation, and Trump's own lawyers are going to hand him $200 million in taxpayer dollars for punitive damages that it is flatly illegal to pay. For comparison, the government paid out $550 million in total claims under the Federal Tort Claims Act in 2022. That's upwards of 3,000 Americans who got into fender benders with the government or suffered a medical injury in a VA hospital or were actually the victims of law enforcement misconduct. And that's the people who managed to get paid. As we said, it's very difficult to recover under the FTCA for anything that isn't a simple traffic accident. Personal injury litigator Nima Rahmani, co-founder of West Coast Employment Lawyers, told The Hill that he had handled hundreds and hundreds of such claims and had never had one be accepted. You make your claim, it's denied, and you file your lawsuit. Senator Lindsey Graham, a staunch Trump ally, says that the president has a right to make a claim if he was wrong, but that's ignoring the fact that thousands of people with much better claims than Trump's are getting rejected every single day. And it completely ignores that Trump's $230 million demand dwarfs anyone else's FTCA award by hundreds of millions of dollars. The New York Times highlights the case of George Redis Jr., a combat veteran of the U.S. Army who was beaten and detained by ICE agents during raids in California in July. Redis says he was trying to get to work, stated plainly that he was a U.S. citizen, and was tear-gassed, pepper-sprayed, locked up for 3 days without being able to wash the chemical irritants off his body, and then released without compensation for his shattered car window. That guy is highly unlikely to recover if he sues because the government will invoke the discretionary function exception. And Trump wants to say that he's entitled to $230 million without even having to go into court. So, who can put a stop to this? Well, probably no one. The Hill reports that Republican senators are disconcerted by this potential illegal payout. Democratic Representatives Jamie Raskin and Brad Garcia have launched an investigation into what they call a blatantly illegal and unconstitutional effort to steal $230 million from the American people. They note that the Constitution's emoluments clause bars the president from receiving any payment from the federal government or any of the states except for his salary, which is currently fixed by law at $400,000 per year. Democratic lawyer Norm Eisen promises to file a lawsuit to block the payout.
If he breaks the law, he will be held accountable, and so will those who are enabling this behavior. If he does it, there will be legal accountability.
But the Supreme Court was pretty hostile to emoluments clause cases the last time Trump was in the White House, mostly tossing them on standing grounds. Plus, thanks to the Supreme Court's immunity decision, Trump can never face prosecution for this act of naked abuse of office. No one can even ask him about it in court. I believe we covered all this last year. The most likely plan here is for Trump to enjoy the fun news cycle, which got Daniel Epstein some airtime, and allowed Team Trump to pretend to be standing up to the Biden DOJ. And then, if Trump loses in November, we'll never hear anything about this misbegotten plan again. But if he wins, then Trump can file his claim and simply order the Justice Department to pay it. He can tell whatever obsequious crony replaces Attorney General Garland to cut him a check for $100 million. And it won't matter that it's wildly illegal, because thanks to the Supreme Court, a president enjoys absolute immunity for official acts. He could make the number $200 million or $1 billion, and there would be nothing anybody could do about it. This is almost certainly going to happen, and there's probably nothing anyone can do about it. In fact, we might not learn about it until a year after the fact, since FTCA payouts are only disclosed in end-of-year reports. So, once again, thanks, Chief Justice Roberts.
Now, all this highlights why it's so important to get a great lawyer when you're dealing with your own case. Now, after I started this channel, every week I'd get hundreds of comments and emails from viewers who are dealing with legal problems. And they'd ask, can you help me find a lawyer? How do I know if this attorney is any good? And there's a massive gap in our justice system. It's that people don't know how to find the right lawyer for their specific situation. They're scared, they're overwhelmed, and they end up doing nothing or hiring the first attorney who calls them back. And that really bothered me. So I started to wonder, what if there was a different way? What if we could build a law firm that actually lived up to the values that I talk about on this channel? Transparency, accessibility, and putting clients first instead of chasing billable hours. A firm where you don't need to pay anything up front, and your lawyers only get paid if you do, to maximize your opportunity for justice. So a few years ago, I decided to fix that problem. I decided to start my own personal injury law firm. And honestly, it wasn't an easy choice. But I realized I was in this unique position. I had this platform, this community, and the experience. Not to get rich, trust me, there are easier ways to make money than starting a law practice. But we did it because access to justice shouldn't be a luxury. Because finding the right legal representation shouldn't feel like playing Russian roulette with your future. And when you work with my firm, you're not just getting a lawyer. You're getting a team that understands that behind every case is a real person with real stakes. If we can't represent you, or you're in a state where we don't practice, we'll take the time to try to match you with an attorney in my personal network of lawyers. A national network of some of the best lawyers in the country who actually specialize in what you're going through, located right where you are, not just whoever happens to be available. So if you're dealing with a personal injury, a car crash, a data breach, sexual harassment, a social security or workers' comp issue, give us a call at the number on screen or click on the link below. Now, I can't represent everyone that watches this channel. I wish I could, but what I can do is make sure that when you need legal help, you have somewhere to turn to that you can trust. So whether it's me handling your case or the incredible attorneys we partnered with, you'll get the same principles of honesty and education that we bring to every video. And if you're dealing with a legal issue and you're not sure where to start, check out the link in the description. Let's have a conversation about how we can help you find not just a lawyer, but the right lawyer for your situation. Because at the end of the day, that's what this is all about, making sure that when life gets complicated, you don't have to face it alone. Which is why when you need a lawyer, you don't just need a legal team, you need the Eagle team.